Today, I'll be dealing with the case MS Universal Sompo General Insurance Company Limited versus Suresh Chandra Jain, which is a special leave petition bearing the citation Civil Appeal number 5263 of 2023. So basically, this case revolves around the right to appeal under Article 136 of the Constitution, or rather, we can say right to appeal by special leave. So, Article 136 of the Constitution of India, as you all know, allows the Supreme Court to grant special leave to appeal against any judgment or order made by any court or tribunal in the country. Article 136, in its nature and scope, enables the preservation of the most coveted principle in the common law system, that is the rule of law. So, over the years, there has been so many decisions with respect to the scope of Article 136. So one of the main decision is in Sanwant Singh versus State of Rajasthan, which was a case in 1961. In this case, the court held that the appeal by special leave can be made in a case where there is a substantial question of law involved or where gross injustice has been observed. Further, another condition to evoke this jurisdiction is that the judgment or degree should have a characteristics of a judicial decision. This indicates that administrative or executive order cannot be challenged. And another crucial thing about this appeal is that uh, this can only be evoked against a judgment or order made by a court or tribunal. So now let's move on to the brief perusal of facts with respect to this case. I'll be just um, mentioning the facts very briefly with respect to the main issue of this case. So recently, the division bench of Supreme Court, presided by Justice J.B. Pradiwala and Justice Manoj Mishra, examined the scope of Article 136 of the Constitution. So moving on to the factual matrix. So this petition seeking leave to appeal under Article 136 of the Constitution was at the instance of MS Universal Sompo General Insurance Company Limited, who were the original appellant before the National Consumer Dispute Redressal Commission, shortly we can say that NCDRC, in the first appeal, and the NCDRC dismissed the appeal, thereby affirming the order passed by the State Consumer Dispute Redressal Commission, holding that the respondent number one, otherwise the complainant, was entitled to receive the claim amount and appropriate compensation from the petitioner and its joint venture partner, which is Allahabad Bank, which is the respondent number two, for the goods stolen. So the moot question that came before this court was before the Supreme Court was that whether to entertain this special leave petition under Article 136 of the Constitution directly against the order passed by the NCDRC, or or relegate the petitioners to avail the remedy of filing a writ petition under Article 226 of the Constitution, or to evoke the supervisory jurisdiction under Article 227 of the Constitution. So relevant provision with respect to this case would be obviously Article 136, about which we discussed earlier. The next would be Section 23 of the Consumer Protection Act 1986. This would be relevant here because the case happened before the new act started. The appeal was evoked before that. And the pari materia section, that is 67 of the new act of 2019. So both the acts provide for the remedy of appeal to this court, that is the Supreme Court, only with respect to the orders which are passed by the NCDRC in its original jurisdiction or as the court of first instance, and no further appeal lies against the order which are passed by the NCDRC in exercise of its appellate or revisional jurisdiction. So here the petitioner has only the remedy, or can only approach the Supreme Court through Article 136, and obviously there is another way, that is Article 32. So in this the petitioners have evoked Article 136. So so the court here had to examine the scope of Article 136. So with respect to that, the court referred to a number of decisions which are relevant here. The first one would be Pritam Singh versus State, which was reported in 1950. In this case, the court stated that Generally speaking, this court will not grant special leave unless it is shown that exceptional and special circumstances exist, that substantial and grave injustice has been done, and that the case in question presents features of sufficient gravity to warrant a review of decision appealed against. And the next one would be Dakeshwari Cotton Mills Limited with the Commissioner of Income Tax, West Bengal. In this case, also the court said that quoting the words of the court, the limitations whatsoever there be are implicit in the nature and character of the power itself. It being an exceptional overriding power, naturally it has to be exercised sparingly and with caution only in special and extraordinary circumstances. Also, in another case, the court had told that only question of law of general importance or the decision should be which shows the conscience of the court. These were the conditions laid down in Ujagar Singh versus another uh, and Delhi administration. And the next one would be State of Bombay versus Ratnalal Vadiwal and Bros. In this also the court stated that we have frequently noticed that all the remedies which are open to an appellant are not first exhausted before moving this court. So ordinarily, this court will not allow the High Court to be bypassed in this manner, and the proper course of an appellant is to exhaust all its remedies before evoking the jurisdiction of this court under Article 136. Now, the another important case would be SG Chemicals Dyes and Trading Employees Union versus SG Chemicals and Dyes Trading Limited and another. This was a case in 1986. In this also, the court stood with its earlier decision that uh, Article 136 is not designed to permit direct access to this court where other equally efficacious remedies is available, and where the question is not of public importance. So another one of the main decisions referred in this case was Ibrad Faizan versus Omaze Build Home Private Limited, which was a decision recently, that is 2022. This case actually bear the same circumstances and facts as the present case itself. So in this case, the court first examined whether the NCDRC actually fell within the meaning of tribunal, which stated in Article 136 as well as under Article 227. So it said that it falls within the meaning of tribunal, and after that the court held that that the remedy available to the aggrieved party against the order passed by the NCDRC in an appeal under Section 58, subsection 1, subclause A3, and Section 58, subsection 1, subclause A4 would be to approach the concerned High Court having jurisdiction under 227. So, with all this regard, finally, the court in this case held that the aggrieved party can approach the Supreme Court under Article 136 for the grant of special leave to appeal against the order of a national, against the order of the NCDRC only if it is passed by the Commission in its original jurisdiction. The court, the court clarified that no further appeal will lie against the orders passed by the NCDRC in exercise of this appellate or revisional jurisdiction. So the court suggested or asked the petitioner to move the High Court under Article 226 or to evoke the supervisory jurisdiction of the jurisdictional High Court under Article 227 of the Constitution. So let me conclude by saying that this decision holds importance because this would act as one of the remedy for the huge backlog of cases before the Supreme Court, and which would also prevent Article 136 from being misused. This decision also holds true with respect to evoking special petition under Article 136 that should be exercised judiciously, respecting its discretionary nature. Its sparing use after exhausting all the alternative remedies upholds the sanctity of the rule of law, ensuring justice while preserving the apex court efficacy, and which would allow the apex court to focus more on the matters of constitutional importance. Thank you.